Welcome back once again. This is your professor, Dr. Mark Smith, and this specific lecture is going to be introducing you to IP, or intellectual property, as that acronym is going to note. So this is about protecting your specific ideas, concepts, and anything that you are creating in this class or in other iterations of your courses that you might take, or just in life in general. So there's specific areas of protecting your product or your intellectual property. You have these four different ones we're going to specifically go over. That's patent, provisional patent, trademark, and copyrights. So of course, let's start with intellectual property as a whole. So intellectual property is a creation of any intellect to be assigned to the designated owner. So it's essentially just something that you or one person has created that's specifically assigned to you as the designated owner, creator of a type of product, service, item, whatever. Intellectual property can include copyrights, patents, design rights, some trade secrets, and dress. Copyrights are pretty much artwork, written works, patents, design, etc. Design rights, trade secrets is an analysis or process that you might do within your organization. As far as streamlining, I'll use a fun one like In-N-Out, for instance, probably has a almost like a trade secret structure, IP protection on the process that they do of making specific food items or sauces. And dress is specifically the marketing or the packaging that something comes out in. If you look at like Tiffany Company, they stereotypically have a turquoise packaging structure that is very designated to their brand. And so that's specifically their IP on dress. Artistic work like music, literature, words, phrases, symbols, and designs, pretty much anything like that. Inventions and discoveries. All these are essentially what intellectual property encompasses. And then we'll go over the process of protecting specific items as you go through. So let's start with patent, the first one. Now, a patent is a government authority governing a right or title to a set period of time that excludes others from making, using, or selling an invention or a specific design that you are patenting. This gives you undue rights to pretty much work with what you need to. There are time durations on your specific patent, and they vary based on whatever type of patent you're doing, whether it's utility design or plant. They'll have different time frames on that. Pharmaceutical also has their own patent process as well with their own time duration. U.S. patents are only enforced in the United States. It's under the United States Patent and Trade Office. They're the ones that grant the patents along with enforce them. So no products or services that match yours that infringe on your patent rights can be sold within the United States. Even if other countries knock off or create things like yours, they cannot be sold in the United States. Otherwise, they have to pay royalties or be up to litigation for infringing on your patent rights. Now, the three types of patents that are pretty much most common are utility, design, and plant. Plant is simply agriculture, seed, etc. Design is an actual design that you're creating. A utility is something that does a specific task or process. Patent applications, I'll be honest, are very, very complex, and it's a process to go through. The cost ranging can range between $5,000 and $10,000, even higher, depending on the complexity of the patent. You are going to want to retain a patent attorney to go through and fine tune your documentation and get this done. And patents can take months, if not years, to get processed and passed through because of depending on the complexity and the size of the patent and how much it might match something else. Now, a patent is not necessary to sell your product or not service, but your product, but it is necessary to research to ensure that you're not already infringing on somebody else's. And it also is good to know if you ever wanted to take that down the road of potentially doing a patent for yourself. Now, there is a process called the provisional patent. Now, this has been developed in the late 90s, early 2000s because of the rate of technology changes. It's a legal document establishing an early filing date. So it gives you essentially a, I guess, early right to sell or to produce a specific product or type of utility that you're making before you actually get a full-on patent. Provisional patents can cost around $260 and up, depending on the complexity and if you need to retain a lawyer to get it filed. They typically gives a filer about a 12-month period of protection, so you have a full year of producing and selling your specific product and getting it out there before you have to go down the full patent process. That's how far the provisional can go, and it gives you protection. So if somebody else infringes on your provisional, you can essentially sue them or take them to litigation or take what they're taking from you. After protection period is up, that 12-month period, the patent is abandoned and you no longer have rights to your product. You still, of course, can sell it and do what you need to, but you don't have any protections based on the patent infringement. Now, as far as a provisional is concerned, this 12-month period can be given another 12-month extension. You actually can do this up to 3 times. So essentially, you can have almost a 3-year period of provisional patent process before you'd have to go down the full patent structure. And at that time, you might not even decide you want to do that. Many companies and organizations and people do the provisional and not take the patent to market for the simple fact that the cost and complexity can be robust. And once you get name recognition and understanding in the market, you really don't need the patent protection anymore. If you have a staple name, you don't need to push it. So that's a good way to look at it. Now, another huge one that you will most likely be doing, especially in this class, is a trademark. A trademark is also submitted to the Patent and Trade Office, the United States Patent and Trade Office. They handle patents and trademarks. It's used to promote a brand or symbol. So an image, symbol, any type of, I guess, logo would essentially could be trademarked as your specific, for your specific product, service, company, etc. Even you can trademark yourself if you want. Trademarks can be licensed to others for use. So if you've ever seen organizations that are selling like Disney products or services or Disney characters or anything like that, they are essentially licensing the trademarks and the copyrights on those so they can sell them for themselves. And Disney just collects a royalty on those sales. Many countries abide by trademark law to alleviate infringement. So that way, or like nobody's using the Apple logo in China falsely. A lot of companies, a lot of countries will abide by this so they don't get, I guess, just piss off each other as far as the countries are concerned in the trade agreements that they have in place. You can use that little TM logo if you've ever seen a little trademark logo on anything. Once your trademark is being processed. So once you put in the application, you can start using the little TM logo, and then once it's fully approved, you still just utilize it and go through it. It's not as lengthy of a process. It's not as costly either. I think it's a few $100s to get the trademark pushed through. You can do it all electronically as well. But it is something that's essential if you're looking to start a company and you create a logo and staple of what your organization is about. You want to do that so that way people don't, I guess, misrepresent you or try to reuse your symbol or title on their own products or services to try to generate business or take from you. So it's just a way of protecting yourself that way. And all of you pretty much will be doing a trademark in this class. Now, the next one is copyright. This is not something you most likely will be doing, but the copyright has its own office. That's copyright.gov. It's usually good for life of the author and can be willed to another or a next of kin as far as, if you write a book or some type of literature or short story. That is good. The copyright holds for as long as you live. Pretty much anything that can be drawn, written, expressed on a screen or paper can be copywritten. So you'll want to pretty much, if you're going down that path, you can do that. Software is not something that will be copywritten. It can be protected in certain ways, but with all honesty, code and that type of programming language can be very, very easily duplicated in minor detail. So it's very difficult to go down that path. As if you've probably noticed that similar to like applications like Uber and Lyft are essentially exactly the same type of programming structure. Neither one of them are going to have a copyright on their software or their programming language. And they're not going to have a patent on that as well. They'll just have trademark logos on their marketing material. So that way one of the companies can try to, I guess, pretend to be the other. And that's the way that structure works. So now preparing your product, I've give you a couple different links. I won't need to go into those, but I'll post them so you can get a jurisdiction of them. But you want to ensure there's no patents already out there. So if you can actually do a search to the Patent and Trade Office to see what's out there and available, what you can and can't do. That way you can completely understand what's already out there and you can take a snapshot of. You can check trademarks the same exact way with that link as well, and same with copyrights. But you want to be thorough as far as looking through and making sure that whatever you're creating is not going to be infringed on. If you're doing a service, of course, you don't need to do patent checking on that. But if you have a specific logo or an idea for a name, you might want to check the trademark office to ensure that you're not going to be taking somebody else's. And you can also do general Google searches too, because you might be able to find organizations that match what you're doing. And then that way you can see if they have the proper trademarks or patents in place to kind of infringe or stop you from doing what you want to do, or you might have to change it up a little bit. And that concludes my introduction to intellectual property. If you have any further questions, feel free to message me about it. But in all, that's the jurisdiction of that. We will touch on this more in the legal and regulatory portion of your week, and your week coming up. And then, but specifically, I just wanted to introduce you to this and have you have an understanding of the provisional patent to patent, copyright, and trademark process that you would go through. Again, thank you for your time, and look forward to speaking with you all again.